Hey guys, Hannah Bell, family lawyer, here with today's Family Law 101. Now, in our last video, we talked about the petition and getting your lawsuit started. So now that you've filed, you're ready to go, you need to get notice to the other side that you filed. And what you might think is like, oh, no problem. I'll send them a text, I'll send them an email, I'll show up with the papers at the kitchen table. Now, that would give them actual notice, like they do know about it. But the Texas Constitution requires something more than that. I call it magic pixie dust notice. You have to do it in a certain way for it to work. And the way that starts is you have to request what's called a citation from the courthouse. And I talk about it's like a piece of paper. It's basically your ticket to divorce land, the theme park you never wanted to go to, but you're here now, so might as well get a Coke and come on. But anyway, you get this citation. And kind of the most typical way that this works is that citation, along with a copy of the petition and any standing orders in your county, those are going to be served by a process server on the other side. Now, you're familiar, I'm sure, with what a process server is because you've seen it on TV, right? Like, you've got served, and it's this very traumatic moment. In real life, it really isn't. But that's the idea. So you have a person over the age of 18 who takes the paper to your future ex-factor, and the person receiving the notice and the papers, they don't have to sign anything. It's not like if they don't sign, the lawsuit's not happening. The process server signs it and then takes what's called a return, and that gets filed with the court. And it's like, all right, we're off to the races. Magic pixie dust notice has happened. We've got ourselves a lawsuit. Now, people are often super nervous about that step, and I really don't think you need to be. There's nothing to be embarrassed about getting served. Anybody can serve you or sue you anytime, so just don't worry about it. And you got to get the other person served one way or the other. So just don't let this be a big hurdle. Work with your lawyer. You'll come up with a plan for when and where and how and whatever. Now, the alternative to this, if things can work out to do it, would be to get a waiver of service. Now, this, if it works, it works. But I say this because people often use this as sort of a delay tactic on the other side. Like, oh yeah, sure, I'll sign the waiver, don't serve me. And then it's 3 weeks later and they still don't have notice of the suit, right? So, but anyway, you can do it. It's where the lawyer that's filed your petition drafts a document that says either really narrowly, hey, my name is the respondent and I got this lawsuit, here's my address, signed, notarized by a notary, and then filed with the court. You can also do a waiver, which is the thing that people, if they're scared of waivers, this is what they're scared of. It's a really robust waiver where the other side could be giving up all rights they have in this lawsuit, further notice of hearings. They can even enter a decree or an order without you. So you don't ever sign one of those. And whether or not your lawyer thinks you can get one, maybe. But if either one of those have to be notarized and filed with the court, and that can count as your magic pixie dust notice. So after you've gotten your lawsuit started, you got to get notice happening. You do that through a process server or through a waiver. Nothing to be afraid of. It's just one more step in the process. All right, guys, have a great day.